This is lecture 4.2, Federalism and the U.S. Constitution. In this lecture, we will discuss the constitutional arrangements of federalism. We'll explain the national government's responsibilities under federalism, and we'll discuss the expansion of federal power over time. In order to begin thinking about the constitutional arrangements of federalism, let's go back to a debate at the time of the Constitutional Convention. One of the major controversies in the Constitutional Convention was who has supremacy. Should it be the state governments or the national government? Under the Articles of Confederation, there was an article known as Article 13, which stated that each state shall abide by the determination of the United States in Congress assembled on all questions which by this confederation are submitted to them. In other words, there was language in the Articles of Confederation that said that states had to abide by what the national government had said. Although remember, there wasn't an enforcement mechanism in the Articles of Confederation, so it was weak. James Madison from Virginia proposed a new form of national government that actually would have the power to veto state laws. His Virginia plan wanted this strong national government capable of vetoing the states. The convention delegates repeatedly rejected this proposal because they wanted to reduce conflict between states and the federal government. The language that they settled on is as follows. This is Article 4, Clause 2 of the U.S. Constitution. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. This is known as the Supremacy Clause. And the Supremacy Clause establishes that the Constitution, as well as federal laws and treaties, are the supreme law of the land, and as such, they take priority over any conflicting state laws. The Supremacy Clause also requires that state courts and state constitutions are subordinate to the U.S. Constitution. So how do we know what things the national government can do? Well, actually, the U.S. Constitution is very explicit about what powers the national government has. These are known as the enumerated powers, and most of them can be found in Article 1, Section 8 of the U.S. Constitution. There are a number of major powers that are explicitly granted to Congress in the enumerated powers. And so a few examples of enumerated powers include the ability to impose and collect taxes, the ability to borrow and make money, the ability to declare war, to create courts other than the Supreme Court. The Supreme Court is the only court created by the Constitution. And Congress also has the power to raise and maintain an army and navy. Crucially, another important enumerated power is the ability for Congress to regulate trade, both foreign and domestic. You'll recall that that was a major weakness of the Articles of Confederation, was that the national government could not regulate trade. When Congress is regulating trade between the states, this is known as interstate commerce, and this will become very important in a little bit. One final thing to say here is that the enumerated powers also includes what's known as the Necessary and Proper Clause, and the text of the Necessary and Proper Clause is as such. Quote, Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. This means that Congress has the power not just to do the things explicitly stated in the enumerated powers, but it also has the power to pass any laws that are deemed necessary and proper to carrying out those enumerated powers. For some critics, the ability for Congress to pass laws that are not explicitly stated in the enumerated powers has led them to call the Necessary and Proper Clause the Elastic Clause, because like an elastic band, it can stretch and morph to accommodate a number of situations. So if the national government is given power over all of the things in the enumerated powers, then what is the responsibility of the state? Theoretically, states retain all rights not given explicitly to the national government, and that's according to the 10th Amendment of the Constitution. Here's the language of the 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So theoretically, the notion of states' rights refers to the numerous powers that the states retain. But the ability of states to do what they want has also led to arguments about states' rights in defending slavery and segregation. So this notion of states' rights is a little bit complicated. In some ways, it's a good thing because it allows the states some autonomy. But historically, arguments grounded in a states' rights rationale have been used to justify segregation and slavery and other forms of discrimination. For example, more recently, states' rights arguments were used to deny same-sex couples the right to marry, where states said that they had a right to issue marriages as they saw fit. But this was changed in 2015 after the Supreme Court case of Obergefell v. Hodges. So something to know about American political history is that the federal government has become more powerful over time. And one of the reasons for this is that the federal government has taken on roles that historically have been played by the states. How have they done this? Well, through a combination of applying the Commerce Clause to the Necessary and Proper Clause. By combining the Commerce Clause and the Necessary and Proper Clause, the federal government has expanded its power, and this is especially true in the 20th century. A good example that you might be familiar with in American history is the New Deal. The New Deal represented a big power grab by the federal government, and it was justified through a combination of the Commerce Clause and the Necessary and Proper Clause. The role of this expanded federal power has been important for desegregation as well. So, for example, here's a question. Is a privately owned hotel engaged in interstate commerce, and therefore can it be regulated by Congress? In the 1960s, Congress passed a number of pieces of civil rights legislation meant to end the practice of discrimination. The Heart of Atlanta Motel was a motel that did not allow guests who were African American to stay in the hotel. And their argument was that they were a privately held business that was just practicing their business as they saw fit. But the Supreme Court said that the hotel, because it welcomed guests from other states, was engaged in interstate commerce, and so therefore Congress could regulate it. There's a few examples of how necessary and proper has been used to expand federal power. Another example is this question. Is establishing a bank necessary and proper to regulating interstate commerce? In other words, Congress obviously has the power to regulate interstate commerce, but does it have the power to establish a bank? Well, in 1819, the Supreme Court said yes. In the case of McCulloch v. Maryland, that Congress does have the power to create a bank because it is necessary and proper to its other powers of regulating interstate commerce. A more recent case, is a law that requires people to have health care necessary and proper to Congress's ability to tax Americans? In a case called NFIB versus Sebelius in 2012, the court said yes, that the Affordable Care Act, also known as Obamacare, was constitutional because it was part of Congress's ability to impose a tax. There are other ways that state power is restricted. There are a couple of places in the Constitution where specific things are prohibited to the states. So, for example, Article 1, Section 10 restricts the power of the states to act within certain areas, including States cannot enter into treaties with foreign governments. States cannot coin their own money. States cannot levy their own taxes on imports or exports coming in and out of America. And states also cannot suspend the writ of habeas corpus or pass ex post facto laws. These are Latin phrases, but they basically mean that the state has to respect your due process rights, and a state cannot pass a law saying that an act that was committed previously was illegal. There are a number of other places in the Constitution where state power is restricted. For example, the 14th Amendment prohibits states from denying individuals rights granted to them under the U.S. Constitution, most importantly, their right to equal protection before the law. The 15th, 19th, and 26th Amendments also include important protections of individual civil rights, including a prohibition on state governments and the federal government from abridging the rights of citizens to vote, based on either race, sex, or age. We'll talk more about civil rights in another unit in the class. So let's review a couple of important points from this lecture. First, what is the Supremacy Clause? And you might want to make some notes about what the Supremacy Clause means in operation. 2, what are the enumerated powers? And give 3 examples of enumerated powers in your notes. Finally, why has federal power expanded over time vis-a-vis state power?